Hello, I'm Jeswald Salacuse, Distinguished Professor Emeritus at the Fletcher School of Law and Diplomacy at Tufts University in the United States. I was also Dean of the school for nearly a decade. The Fletcher School is the oldest graduate school of international relations in the United States, and as its name indicates, one of its specializations is international law. I'm very pleased to have an opportunity to teach a course on international arbitration at the National University, Research University Higher School of Economics in Moscow. In this short video, I want to give you an overview, a summary of the course that I will be teaching. I have taught and done research on international arbitration for nearly 4 decades and have also served as an arbitrator for 20 years, and I continue to do so. In this course, I want to share with you my research findings as well as my experience as an arbitrator. International arbitration is an ancient form of dispute resolution, but it is not well known. Certainly, it is not followed in the media, and many law faculties do not teach the subject. But nonetheless, today, international arbitration is an important area of legal practice, not only in private law firms, but in government departments that are participating in arbitration cases involving their governments. Today, it is a significant area of legal practice, and most international lawyers need to know something about it in order to participate in this very exciting part of the law. So what is arbitration? Arbitration is essentially a process of dispute settlement in which the disputants, those parties that have a dispute with each other, in which the disputants agree to submit their decision to a third person or a group of third persons for a binding decision according to agreed upon laws and rules. It's essentially a judicial or quasi-judicial form of dispute settlement, but it's sometimes confused with mediation and conciliation. Mediators and conciliators do not decide the way arbitrators do. They merely assist and help negotiators to arrive at an agreement. Arbitrators decide. They are like judges in this respect. But unlike judges, which receive their authority to decide from the law, arbitrators receive their authority to decide a case from the agreement of the parties. International arbitration are basically cases that involve parties from different countries. That's the dimension, the international dimension that gives it this quality, because there's something also known as domestic arbitration, which I will not be talking about in this course. The course that I will be teaching examines the 3 principal types of international arbitration. The first is interstate arbitration, that is arbitration of conflicts between 2 states, often over matters, for example, of borders and of territorial sovereignty. The second type are cases between private parties of one state and governments of another state. And one of the subtypes of this kind of arbitration is what is known as investor-state arbitration, where private investors, private companies, bring a case, often under a treaty, against a government of a state where it is invested on the grounds that the government has injured the investor by not respecting international law and treaties. And because of that, the investor is seeking and many times receives significant compensation for that treaty violation. And the final type of arbitration is what is all generally called international commercial arbitration between two parties, two companies from different countries, often involving an international transaction such as a contract of sale of goods or for the transfer of technology. So these are the three that we'll be looking at, and the course will be organized around that structure. In looking at each type of arbitration, we will examine the entire arbitral process from the beginning, from the negotiation of the arbitration agreement, which of course is fundamental to any arbitration case, to the decision by the tribunal or the arbitrators on the matter. And even after that, we will examine how winning parties use the law and other strategies to collect on what they have been awarded by the tribunal. And at the same time, we'll also examine how losing parties seek to avoid having to comply with the tribunal's decisions. Arbitration cases are private. Unlike court cases, they are not open to the public. You can go into court and watch a litigation. You cannot, as a member of the public, enter an arbitration hearing room and watch the proceedings. Nonetheless, based on my experience as an arbitrator and my research in the topic, I hope to give you some insights into the arbitration process that may be useful to you as practitioners of law, either in government or with private firms. In today's world, the international arbitration cases involve substantial amounts of money, often hundreds of millions, even billions of dollars. They employ numerous lawyers and other experts, economic experts, for example, technical experts, and have significant consequences sometimes for the policy positions and indeed the very policies of the states concerned. The world of international arbitration, I find, is a fascinating and exciting world. I hope to convey some sense of that fascination and that excitement to you during the course, and I very much look forward to meeting you.